Good afternoon.
Afternoon.
Are you well?
Yes, I'm well.
Good, good. I'm fine too, even if you did not ask.
Thank you, DCJ.
You went to Forte and Wits.
Yes.
Which degrees did you obtain from these fine institutions?
Forte, B Juris and LLB. Then at WITS, higher diploma in company law. Although I didn't include it in my CV, I also done the LAM in labor law with UJ, but I finished the coursework. I passed the coursework. I was busy with the dissertation of sexual harassment at employment, but due to family problems, I couldn't finalize my dissertation.
Well done. I always admire people who study while working. I don't know where you find the time, but, well, my hat's off to you.
Yeah.
You stayed on at Forte as a lecturer for 3 years.
Yes, DCJ.
Which subjects did you teach?
Private law and interpretations of statutes. Private law one, at the time, they had a branch in Bishop for adult after hours. So I also done teaching private law 2 and commercial law in that particular place.
All right. But then you left teaching. You left the noble cause. Why did you leave?
At the time, I was still young. I felt that was boring for me. And I wanted just to be an advocate. That's what I wanted to do.
All right. And you became a prosecutor?
Yes, I started at some stage as an interpreter, district court prosecutor, then original.
You started out as an interpreter, then you became a prosecutor, then you rose to the ranks of the magistracy.
Yes, yes, this is it.
Well, that's the route I followed as well.
Yes.
All right, so you remained a prosecutor for 3 years and then became a magistrate, a district magistrate.
Yes, this is it.
But soon became a regional magistrate, which you still are.
Yes,
And have been for 22 years now?
Yes, for 22 years as a regional magistrate, altogether 26 years as a magistrate.
All right. You have acted as a judge?
Yes.
Where, how long?
In Gauteng, since 2016 up to now.
And since 2016, you say?
Yes, since 2016.
What has taken you so long to apply for permanent appointment?
I thought that I needed to be more equipped and to learn more instead of rushing, so that I can be able to understand everything. And when I'm ready, then it's now that I feel that I'm ready to apply, because at the time I felt that I'm not yet ready to do that.
Well, that's a good enough answer for me. All right. I'm going to hand you over to JP Mlambo.
Thank you.
To quiz you. JP Mlambo.
Good afternoon, Mr. Manyathi.
Good afternoon, JP.
And I also want to thank you for availing yourself for this interview and for being available to act in the division.
Thank you.
When I was looking for people. Now according to the allocations, you've acted for a total of 63 weeks in Gauteng.
Yes.
And 49 of those have been in the criminal trial courts, am I correct?
That's correct, JP.
Yeah. That's, in a sense, reflective of where you've spent most of your professional life as a judicial officer in the criminal trial courts, am I correct?
Yes, although at some stage I was doing the civil in regional.
Yes.
Yeah. Especially because I'm stationed in Captain Park.
Yeah. Try and speak closer to the mic.
I'm stationed in Captain Park,
yes.
And at the time we had only one a regional magistrate that was dealing with civil. Now she was doing Captain Park. She does also Springs, I think Springs and Brakpan together, and Heidelberg.
Yes.
So most of the time she's not at the office. So on the days that he's not there, I will actually do any civil matters that appears. I will also help her with in issues of divorces divorce role when she's not there.
Yeah. You may not want to answer this, but you know, in the high courts, we sit with the problem that the civil work that must be done in the regional courts comes to the high court. We've done all we can, I know, in Gauteng, to dissuade lawyers not to bring that work to us. And they complain that they don't get justice in the regional courts when they take their civil work there. You've acted in the high court, you've done some civil work in the high court, and you are aware that most of that civil work belongs in the regional court. Am I wrong?
You're right, JP.
What should we do? Because to me, it tells me that the conscious decision made to make sure that instead of going for costly litigation in the high court, it should be done in the regional court, but it's not happening.
I think there's something more that must be done, JP, in order to do that, because we actually in Captain Park we are getting a lot of civil matters, as I've
Yes.
said, and I don't know other clusters, but we try by all means. As I've said, we've got only one. That's why I must sometimes help, but I cannot be able to say at this particular stage what might be the reasons why they feel like that particular way.
I'm not blaming you. I hope you're not understanding it as I'm blaming you. We need help to see what we can do to make sure things run properly. That's why I'm raising it with you, because you are involved in that court level. You know.
Yeah, I think, as I've said, JP, I think more must be done in order to be able to help, especially people who are appearing there. Most of them are people from the locations, Tembisa and all those particular people. And at least if that can be, something must be done to encourage them so that their cases can be finalized as quickly as possible.
Yeah.
And actually to help those people that does not have money to come to the high court where the costs are involved at an end. But I think they're not as, if we can actually develop that particular area, I think that will actually help a very good way.
Now, you've done some civil work in the High Court. I see you've also done a week in the Agent Court.
Yes.
Was this during recess?
No.
It was during, who was your partner in crime when you did the Agent Court?
That was Judge Malindi.
Judge Malindi, oh, okay. So that was during term. And you've not done special motions, even though you've done, I think, it shows me that you've done 2 weeks of opposed motions.
Yes, I've done 2 weeks, one in Pretoria, one in Johannesburg.
Yeah. How long did it take you to finalize the reserve judgments that you accumulated in the opposed motion courts?
I've actually done most of them in 3 months, before the end of the 3 months.
Yeah.
There was, I think, 1 or 2 that there was a cycle. I finished them within time, but they were delivered late because the secretary that was helping me in Pretoria, especially in Pretoria, I don't know what is the problem. Apparently he resigned or his contract ended, and without actually handing those particular judgments to, but they were written in time.
Yes.
And I finalized them within 3 months' time.
Yeah. Now, as is clear from the spreadsheet, you haven't done work in the full court appeal area. You've done work in the full bench area, am I correct? Where it's a magistrate's judgment, that's on appeal.
In criminal?
Yeah.
No,
in civil. In criminal, yes, you would have said in a full court, am I correct?
I've said both in civil, full court in civil as well as criminal.
Yeah.
And I've penned those 2 judgments.
Right. What was your bench in the civil one?
That was Judge Sadwala and Judge Davis.
Davis, the Pretoria judges?
The Pretoria judges.
Okay. And then in the criminal one?
That was Judge Spilch, as well as acting Judge Ngube.
I see. But you penned those two judgments?
Yes, I penned those
Okay.
two judgments.
That's good.
I
And
think
then-
the one of, I think the appeal one, the criminal one, I had to read about 12,000 pages of that particular judgment.
Now, what I've said to the other candidates, you would have seen it if you guys are watching in the holding room, that I would like to see this commission recommend candidates who will not be a burden, even though they are there, but won't be a burden to other judges. That is, if I say I want to give you a special motion, I don't have to think twice. I don't say, I can't give it to him because no judgment will come out, or judgment will take 2 years.
Yeah.
You understand? Because I do have instances where the parties will look at the duty roster and see who's there, and they'll write to me and say, look,
Yeah.
we provide this evidence why we don't want this judge to hear this matter, because judgments never come out.
Yeah.
That's what causes me to say the pool that I must use of people who must do the heavy work has continued to shrink, and I want people who will help me in that regard. You understand that part?
Yes, I do understand.
Yeah. Now, I'm saying this to you to say, I would like the commission to make sure that the technical competence of recommended candidates is at the correct level to do the work in the division. Obviously, these must be people who are hardworking. You've been in the division, you know the volumes we deal with. You've just mentioned 12,000 pages,
Yes.
which is one appeal. And your conceptual grasp of the issues you're dealing with needs to be at the right level. You understand that?
Yes, I do understand, Jacob.
Right. Now, what is your comment to what the bar is saying about your candidature for permanent appointment, the GCB? Have you seen it?
Which one is it? Okay.
I think they are saying effectively that your strength seems to be more in the criminal
Okay.
law arena, and that you may need more time in the civil law arena.
I don't blame them, JP, because I think they had only the application without the spreadsheet of the cases that I've done.
Yes.
And if you notice, some of the appeals, I've written them, some of the judgments in civil, I started somewhere in 2017.
Yeah.
What used to happen is that in a term, I will finalize my criminal appeals before the term ends, and I will have about 6-7 days that I don't have any work after I've done a look to other criminal judges in respect to help them with the petitions. I will go for a roll call,
Yeah.
where they will give me a 2-day or 3-day, especially unlawful arrest, as well as ref matters.
Yeah.
So I will do those particular things until I've been doing that since 2016, because if you can check, I've been finishing my role before the end of term. Then I will go for civil court roll call in order to get some work, civil work to do. Although, as I've said, on a little bit scale of 2 days trials for unlawful arrest. From that time up to now, I think I've done almost 10 or 12 of those particular judgments.
No, in fact, I want to confirm to the commission that you are one of those acting judges that when your criminal trials collapse, you go to the DJP to say, I'm available, I need work. Because
Thank
you know he's always looking for people to help.
Thank you.
You always do that, I know that.
I always
Right.
do it.
If you look at paragraph 6.1.1 of the GCB comments, the bar criticizes you as to how you resolved or approached the issue of locus standi.
Yes.
Do you have it there? Have you read it?
Which case? The case of?
It's the case of tenants of Waterford Court and two
Okay.
others. Yeah, you saw that.
I've saw that.
You are aware of what they're saying.
I'm aware of what they're
What's
saying.
your response to that criticism? Is it well-founded, or is it unfair, or you don't agree with it?
I don't agree with it. It's unfair. In that particular matter, as I've said, I've found that the matter was not urgent,
Yes.
based on the fact, firstly, that they received the notice of the termination in February.
Yeah.
And the application was done, all the other things were done, but the application was actually done somewhere in October. Secondly, I found that on the basis of lack of locus standi,
Yeah.
because the applicants were not actually the owners of that particular building, neither were anything that shows that they were related to anything to that particular. To me, it appears like as if people would just group and enter the building, and they were owing the municipality plus minus 2.5 million on services.
Yeah.
So,
So you don't agree
again,
with
I
the
don't
criticism?
agree with them. That matter, at some stage when I checked, the same attorneys, they brought it back to one of the senior judges, and on the same facts, the senior judge again gave the same judgment that I gave, the same. So that's why I say I don't even agree with what
I
they
see.
said.
Okay. So you regard yourself as eminently ready to be recommended for permanent appointment?
Yes, JP, I think as I've said, as the Deputy Judge, Chief Justice said, I've waited a long time, and I've done because I wanted to equip myself with almost all the areas that are available.
Yes.
I'm accustomed to what is happening in the division. It's very busy. I've become accustomed to the fact that as a judge, you don't go to bed at 9 o'clock. You don't have weekends. You don't have public holidays.
Yes.
So your book becomes a library because you have any time that you have to read. So I know how the division is so busy.
Thank you. Thank you, DCJ.
Thank you, JP. MEC, do you have any questions for this candidate?
Thank you very much, and good afternoon to you.
Afternoon.
My questions would have really been around the criticism that the JP has spoken to, but I think you have dealt with that quite adequately. Although I would have just wished one comment on, what will you consider to be your contribution broadly to the body of knowledge in the legal profession, based on this observation or criticism that you're more in the criminal law space, but broadly, while I take the points you've made, but what you do say you have contributed to particularly research, contributing new things to the development of the law and all that.
Thank you very much, Commissioner. As I've said, that I believe that as a judge, you must be able to know all the law, parts of the law, civil and criminal. And it is also a fact that none of the judges that knows 100% civil and 100% criminal. Each judge has got their own strength. I'm of the view that although I actually have more strengths on criminal, I've done a lot of also civil matters. As you see, I think one of the bundle, the senior judges, they trusted me with an appeal, and I penned that particular judgment, which they were very much happy. They sent comment that they were satisfied with the job. So I feel that I actually do the research. I read my spare time about things that I needed to do and to read in respect of other fields that I haven't done because I've not received any case that relates to those particular issues.
I can leave it here. Thanks.
Yes, dear.
Thanks. Good afternoon, Mr. Manyathi.
Good afternoon, Commissioner.
I'm going to be asking you, look, I'm only allowed to really ask you one question, so I'll try and put it all in. But it's about the State versus Christo Smith judgment.
Yes.
Where you overturned a sentence, the accused raped. The accused was the boyfriend of a young girl who was 13 years old. The accused was 39,
Yes.
and he raped her. The rape was upheld, and the issue is the sentence. And as you know, the legislature has set a minimum sentence for child rape.
Yes.
That is the intention of Parliament. These cases are serious, and therefore the minimum sentence for rape of a child is life sentence. You, however, say, no, I'm of the view that life sentences should be used sparingly and for very serious rapes.
Yes.
You do say things which are in the judgment about, you're meant to find, and I'm going to be asking you, what are the substantial and compelling circumstances? What I can find from your judgment is that the rape happened at the spur of the moment. The victim did not sustain any injuries. She's responded well to trauma counseling. You also then say, no, because the complainant and the appellant stayed under the same roof for a period of 8 months when the incident took place, because the accused was the boyfriend of the victim's mother. You say, therefore one will approach this matter as rape by a family member. I note in your judgment you did quote a number of cases. You did not quote State versus Manyathi, which is a 2011 case, which is a more recent judgment than any of the judgments you quote, where it says Parliament had ordained minimum sentences for certain specified offences, and these were to be imposed unless were truly convincing reasons for departing from them. Courts were not free to subvert the will of the legislature by resorting to vague, ill-defined concepts such as relative youthfulness or other equally vague and ill-founded hypotheses that appear to fit the particular sentencing officer's notions of fairness. Predictable outcomes, not outcomes based on individual whim, were foundational to the rule of law. So look, I just want to give you a chance to respond. I find your judgment induces a sense of shock for me. This is the rape of a child. Parliament has said substantial and compelling circumstances not to impose a life sentence. Please tell us what those are. And tell us if you regard the rape of a child by a 13-year-old girl, by a 39-year-old man. Is that not a slightly very serious offence?
Thank you, Commissioner.
You gave 12 years.
Yes. At the start, I want just to express that a rape is a very serious offense. No one can argue in the contrary that rape is not a serious offense. I think the legislature, the manifest purpose of the legislature is to make sure that a serious sentences are being passed for such particular issues. But on the same time, when you look at the Minimum Sentence Act, it also gives a discretion to the judicial officer in terms of Section 51, subsection 3, as to state what are the substantial and compelling factors to deviate from the prescribed minimum sentence. You read the cases of Mahamudzi, 2012, where the retired judge, I think, I'll remember just now. But when you look at those particular cases, State versus Mahamudzi, State versus Vilagazi, State versus Abrahams, and all those particular things. But as early as 2002, the judges started to understand and try to give a guidance as to what is meant by substantial and compelling factors for the court, especially in respect of the minimum sentence. Judge Cameron and the others, when you look at those particular cases, it states that the courts are not supposed to slavishly adhere to the minimum sentence. The manner in which the offense is committed, the factors, how is it committed, those particular issues must be taken into account. As I've said, that the fact, it might give the impression as to the quote that you give that I'm saying, because it's a family member, then it's different. When you go a little bit down in that particular thing, I said it makes no difference whether it's a family member or not. Rape is rape. Mahmoud says that other rapes are more serious than other, are totally different. Now, I think the legislature, because our duty is to make sure that we interpret laws, we don't make laws. Now, clearly, when you look at the fact, the manner in which the rape took place, to me, it also formed one of the substantial and compelling factors. Now, in this particular matter, it was not a planned one, and secondly, there was no violence that was used. And when you look at the minimum sentence, the issue here is that the problem that we're having is that he was actually charged with the extended definition of rape. That was not the traditional rape that we know. The issue there, the facts, is that a tongue was used. I'm not saying that it's not rape. Don't anybody take me as if it's not a rape. Rape is rape. What I'm saying is, it depends on the manner in which rape has been committed. That will determine as to whether the life sentence must be imposed or not imposed. So, as I'm saying, when you look at those particular factors, the response, the report that I got into this particular child, she was traumatized, I understand that. I will not sit as a judge and a presiding officer and pretend to know how does a woman feels when after being raped. The fact is that rape is rape, and a certain minimum sentence is actually prescribed, but we cannot slavishly adhere to that. There are certain factors that the court has to look in order to. I felt that the life sentence was too much it was disproportionate to the facts of the matter. Hence, I arrived at the issue of 12 years imprisonment.
Thanks. Well, so you're saying the substantial and compelling reasons were that the rape wasn't planned. You're saying the substantial and compelling reasons were that there was no violence, which probably is a bit difficult for a 13-year-old girl against a 39-year-old man who she knows who's her mother's boyfriend. I mean, with respect, Mr. Manyathi, and then also, as I said, why didn't you look at Machichi, which is a SCA case more recent, 2011, than the ones you were quoting in your judgment?
As I've said,
So basically, I have to say I'm quite horrified by your judgment and your approach to the issue of rape.
Commissioner, sorry, just to add to that, when you look at the recent case of State De Beer versus the state, in that particular matter, it's a Supreme Court of Appeal decision. In that particular matter, the stepfather actually abused the 8-year child for a period of almost 8 months. And the High Court, after the magistrate court gave her 15 years, of which 5 years is total suspended. The High Court increased it to life sentence. The SCA was of the view that the death was too harsh, and they actually dismiss or set aside the life sentence. So what I'm trying to say is that I actually read the latest that I have, especially De Beer's case. It's, I think 2014, if my memory serves me well, it's a 2014.
Okay, but you don't quote De Beer, so we'll have to look it up. But it's interesting that you're referring to De Beer now, but it's not in your judgment. Just a note on that.
Just a follow-up, CJ.
Follow-up.
No, it's just a quick one. I'm just following up to the minister. Deputy, I'm not sure whether you get the Deputy Minister, and I don't believe you understand the Deputy Minister, the Commission. It seems as if your approach is that irrespective of the fact that there is a minimum sentence, there's a legislation, your point is that you must lavishly apply with the minimum sentence. I think that you are wrong. because the starting point is to accept that a legislation has been ordained which prescribe that life sentence or whatever minimum sentence has been prescribed. And then once you do that, the next approach is to then look onto the facts of the particular case so as to determine that these circumstances justifying a deviation do exist. But yours is the other way around. And hence, you, in your response to the minister, you cite all the cases which are totally relevant to what he is asking you. Because here, what were these factors? Is that there's no violence? Is that is a family friend? I mean, what is that?
That's what I'm saying. Sorry, Commissioner. That's what I'm saying. I'm not saying that it's not a serious offense. What I'm saying, because that has to do with the Minimum Sentence Act, the prescribed minimum sentence, as to how should one approach that. So I'm of the view that the circumstances, the manner in which an offense that carries a minimum sentence on its own, one has to look at those particular issues and form whether is it a substantial factors, because one cannot be able, the Act doesn't say what amounts to a substantial and compelling factors. It depends on the merits and the facts that are placed before me as to what is the situation. So, as I've said, that it was a first offender. As I've said, that the issue, there was also no violence, and there was no violence, and it was not, that's what I'm trying to say, that those are the factors that I took into account at that particular stage.
Thank you, TCJ, but I'm not satisfied. In fact, you still don't understand how
He's
do you
given
move
his
about.
answer, Commissioner.
Thank you. No, thank you.
Do what you will with it.
Okay.
Yeah.
I also want to just do a short follow-up, like a shorter than Mr. Nojesi.
There are two follow-ups before you, Commissioner. Commissioner Pillay?
Thank you, DCJ. This is just a quick follow-up. Good afternoon, Mr. Manyathi.
Good afternoon.
Can I follow up on what Commissioner Nojesi has put to you? And it really is, and this is where you two seem to be speaking past each other. It's the approach that you used is an incorrect approach. If you look at paragraph 15 of your judgment, you say, in the evaluation of the facts before me, I'm of the view that the learned magistrate put much consideration to the seriousness of the offense and the interests of the society above the personal circumstances of the accused. Lastly, that the degree of severity in this matter is not that serious. You were applying the Zinn test, which is a completely different approach to sentencing. You disregarded the minimum sentencing dispensation, and that's the problem. You acted as if you've got a discretion which you exercised from scratch, and you took into account the Zinn factors. You didn't depart from the perspective that the minimum sentencing legislation is in place. That's what the legislature ordained, and your only job was to check as to whether or not there are substantial and compelling reasons to depart. That's the distinction.
As I've said, Commissioner, my approach was automatically the first thing that one has to do is to check whether there are substantial and compelling factors to deviate from the prescribed minimum sentence. What I did was to look at the factors, the facts of that particular matter, whether the sentence that has been imposed, is it disproportionate to the offense that has been committed. Now, at the same time, when I look at the fact that he was a first offender, looking to the fact that there was no violence that was used, and I've not actually planned, it was just a spur of a moment, but still the fact is that he committed this particular offense. I felt that the issue of life sentence was disproportionate to the facts at that particular time. But as I've said, if the Commission feels that that was a wrong approach, at the time, I bona fide believe that that was the approach that I wanted to do, that I was supposed to do at the time.
Thank you, DCJ.
There was a follow-up question from the virtual platform. Who was it? Have they given up? Okay.
Dodova was right after all. It's just.
No, he was not
No,
right.
Let's,
it
let's
was
just,
me, DCJ.
Yes. Who was it?
Yes, it's Clement.
Go ahead.
Good afternoon, Magistrate.
Good afternoon, Prof.
Yes.
I can see
I'm
you.
also concerned with this case, in a sense that you are using the word violence. And I just want to understand in what way you are using the word violence. I cannot think of any way of thinking of violence than somebody actually violating you by putting any part of their body into your own private part. I think that is violence enough. But over and above that, I just want to understand from you, when one deals with the question of rape, are there degrees of seriousness? And what determines whether an act of rape is more serious than the other in such a way as to deviate from the minimum prescribed sentence? Thank you.
Thank you, Commissioner. As I've said, when I'm talking
DCJ,
about,
So sorry, it's the same question. I just want to add something on the same question that Prof has asked. If you allow me, can I just do it so that he package it, if it is possible? Okay. My simple question is, what is not violence in rape, especially a statutory rape? What will constitute non-violence?
Commissioner,
Or put differently, DCJ. Or put differently, what is your definition of violence?
no, in this particular matter, Commissioners, I was talking about physical in the sense of assaulting or stabbing. As I've said, the fact that we take it very seriously, that any rape is serious. That's why the extended definition that if you use any part of your body is rape. The rape is rape. But as I'm saying, you look at the facts. How is the matter being committed? How is this rape is committed? That's why I'm talking about the degrees of commission, the action itself, not the rape itself, but the manner in which the rape has been done. That's why I'm talking about that particular issue.
But
But
DCJ,
rapes are all of them are serious.
DCJ? But we agree that rape is violence. Should we agree on that one? That rape on its own is violence?
Yes, Commissioner Malema, I do understand your side of the thing. That is a violation.
Side of the thing.
That is a violation of a human. And a rape, as I've said, is serious. But when you look at the cases, as I've said, when I'm talking about, when I referred to the issue of violence, I was actually meaning maybe it might have come out in totally wrong, but there was an issue where somebody has stabbed somebody or assaulted this particular woman. That's what, when I'm talking about violence in that particular sense. But I do agree that rape on its own is rape in a technical sense, is violence.
yes, I mean, DCJ, I wonder if maybe I can help the candidate. I think the problem that you don't have to answer this because I think you've attempted to do so in response to Commissioner Pillay. I think the problem that you are being pressed on, certainly from this side of the table, is that you've distorted the test. You know, if you look at paragraph 14, in cases of this, of your judgment at page 30,
Okay, you can post it.
Do you have it?
I'll check. I'm trying to check.
no, let's just go through it together. Maybe you can concede and then we move on.
Yeah.
It's page 30, paragraph 14. It looks like you're looking at the wrong bundle.
Sorry about that.
No, I know the feeling.
Sorry about that.
Yeah, so I think the point that is being put by Commissioner Pillay is that you've distorted the law. Because the way you express the law is that in cases of this nature decided by the Supreme Court of Appeal, the message is that it's clear that life sentence is the most severe which a court can impose and must be regarded as a last option. Now that's where the distortion is. The law is that it's the first option, unless substantial and compelling reasons exist. So that's where you are misunderstanding the law. That's what is being put to you. Okay. The second thing around this misunderstanding, it looks like you are not the only one, because when you turn to page 32, the judgment is concurred in by a senior judge.
Okay. I think I've got it.
Yes, but you don't have to answer because I think you've already taken enough.
Just one quick other follow-up. Mr. Manyathi, you speak about the extended definition of rape. I'm not sure what you're talking about. There was a common law definition of rape, which was more narrow, which was repealed by the Sexual Offences Act in 2007. And then there's one definition of rape, which is person A who unlawfully and intentionally commits an act of sexual penetration and with a complainant B without the consent of B is guilty of the offence of rape. Full stop. That's a definition of rape. So what's the extended definition? There's compelled rape, which is not one of the factors here. That's the third person. So, I mean, even with respect, I suspect you are looking at the old common law definition of rape, which was repealed as being the correct version, and the statutory definition of rape as being the extended version. And let me assure you, it's not an extended version, it is the current definition of rape.
Yes, Commissioner, I do understand. As I've said, I think what I'm trying to say, as I've said, Commissioner, is the fact that when those issues that were indecent assault and other issues, they are now actually rape. That's what I'm talking about, because initially there's certain part of the body that was used before it can be regarded as a rape. But now the Act talks about any part of your body and any other objects. That's what I'm talking about when I'm talking about the extended definition of rape. But as I've said, if that was the wrong approach, I think it came in a wrong way, the way I put it, but that was not what I meant, and I accept what the Commission says.
Commissioner Lucas?
Thank you very much, DCJ. Good afternoon to Mr. Manyathi. Is it Manyathi? I was listening to the candidate, and I think I want to ask him to forget about the technical approach that he's actually bringing to this panel, and tell me whether, in the light of the high prevalence of gender-based violence in this country, someone just Monday responded to say that they realize that South Africa in some aspects can be seen as a lawless country, particularly if you look at the high prevalence of gender-based violence. Now, while you are sitting on the bench, whatever kind of judgment you give become kind of precedents. Have you taken into account how many children is being endangered by taking a decision technically that you have got, what do you call it, that you can decide discretion, that you have discretion whether you want to impose a minimum or a maximum or a minimum sentence? Have you taken into account how many of us, or do you expect us as women here to agree with you and say that you are fit and proper for us to recommend that you should be appointed. Because we are very disappointed, and I don't become a board anymore. What is happening is that it is very, very painful to hear someone speak and making something that is so painful a technical issue. DCJ, if you allow me, I want to tell you, I was in the United States of America earlier in last month. And you know, because of the time difference, we are reading South African news all the time. For the 4-5 days that I was in America, every day, 2 women at least was killed and raped. And that is why we don't know how someone can be technical about the issue of rape.
Thank you, Commissioner.
Thank you.
As I've said, Commissioners, I take rape very seriously. Maybe the manner in which I've put it is the weights in that particular judgment sends maybe a wrong message. In my instinct as a judge in this province, I've actually done more than, I think, 5 cases that has to do with rape, where the accused has been sentenced to life imprisonment. Last month, I think in January this year, in Captain Park, I sentenced the accused who was sleeping with his own daughters, that are 3 of them, that were underage. I gave him 3 life sentences plus 30 years on top of that. What I'm trying to say is, I'm very much sensitive to the gender-based violence. I think some of the cases that I've gave to you, that shows that I'm very much sensitive to those particular issues where gender-based violence are involved. You can see also in one of the cases that I've quoted, the one of Palisa Modiba, a UJ student. I'm very much serious about those particular issues. But as I'm saying, that I might have use a language that is actually not correct in this particular matter, but that on its own, as I've said, I think I will have to look at that at the next time as to how do I put that in a proper perspective. But I take gender violence very, very much seriously.
I think the difficulty, Mr. Manyathi, is that you strenuously defended this obviously flawed judgment of yours. And it's not just the reasoning. Well, you are backtracking on your reasoning now, but the sentence you imposed there shows exactly what, how you understand the notion of rape. You imposed a mere 12-year sentence, which backs your flawed reasoning. How do you account for that? And then you come here today and you continue to defend this judgment when so many people are trying to show you where you went wrong. I've not heard you concede to this point that you were wrong in that judgment.
Thank you, Commissioner. As I've said, that I thought that the way I put it and the manner in which I've done, I was of the view that I'm in the right track. But as the commissions are pointing out, I cannot dispute what their views is. But at that particular stage, that means that next time I have to be very much careful about that particular issue. I do agree and accept what are they saying.
Commissioner Baloyi?
Thank you, DCJ. Good afternoon, Mr. Manyathi.
Good afternoon.
DCJ, my question, in fact, becomes a follow-up on what you're saying. Mr. Manyathi, the courts speak to the public and to the parties that appear before them through their judgments. And it is therefore important that the orders that you get to are reasoned. When you read the body of the judgment, as a party that before you, when you read the judgment, you want to see an explanation of why an order was given. You reduce the sentence to 12 years. There's no reasoning why 12 years. Why not 5 years? Why not 20 years, right? So this child of 13 who has been subjected to violence, because it is violence, has been subjected to violence, has no idea why you have sentenced you have reduced the sentence to 12, why in fact it is 12 years. And all you tell us is you've taken into account the personal circumstances. And the only personal circumstances in this judgment is the accused is 39, he's got a son of 17, he's an IT specialist who earns so much. Those are the only personal circumstances that are in here. And we have to have, you want the public to have faith in the decisions of the courts and how they come to the decisions of the court. But it will not happen if we don't explain ourselves. And I make the point because whether you get appointed or you continue to act, you are going to continue writing judgments, even if you're acting. You have to understand and appreciate that you owe it to the public to explain your orders. You have failed dismally to do this. In fact, as a result, the impression is, well, you take rape lightly, this kind of rape lightly, hence the 12 years.
Thank you, Commissioner.
Thank you, DCJ.
As I've said, I do accept, as the Commission is of the view that that is the issue, I do accept that maybe I've made a mistake. I do understand in respect of the approach. But at the same time, as I've said, I promise that I also take that serious, any rape matters, as well as any gender-based violence offenses, I take them into seriously. But I do understand what the Commission's concern is. But as I've said, I will try to next time to sort out the way that I've done it, the approach that I have.
Mr. Manyathi, you've come 7 years after you've done this judgment.
So-
You've heard all of us say you can't justify your sentence and your reasoning. And yet you continue to say, I hear what you say, which means your view hasn't changed and we haven't helped. So what do we do? Which appears that you've written the judgment today, the way you're defending this. But you come here for an interview. We're telling you about the difficulties. We're telling you that there was maybe an error at best for you, and you don't admit that. You justify the unjustifiable, and you continue to do so today. And I have great difficulty with that. That causes me serious concern.
Yes.
Because I see this judgment as if it's written today. And by the way, it's not a 12-year judgment, it's a 10-year judgment, because you antedated this judgment.
Yes, Commissioner, I do understand. Maybe I don't put it, I do accept that the Commissioner's view, I do accept that there was, maybe the approach was wrong. I do that I was wrong, and I've said it's one of those regrettable errors, and next time I'll try to be able to do that. I do agree and accept the Commissioner's view in this particular matter.
Yes, Commissioner Malek.
No, just a very brief follow-up. Apart from the law that the other side has shown and everybody else has spoken, in particular Commissioner Lucas, and how this has become a huge problem. Now a cardinal mistake has been pointed out to you that child will never recover from. That the admission you are making here now confirms that she has never received justice, she will never receive justice. In the spirit of Ubuntu and Africanism, having accepted all of this wisdom that was shared with you, Judge, collectively, don't you see that you should take this opportunity to really sincerely apologize? Because it will go a long way to heal some of the wounded women of our country who have fallen victim of this, and there is a general acceptance that they are not. Is there a problem, Commissioner Nonjes? No, but I see you two citing the DCJ with a hand sign. You want to stop me?
Commissioner Malem, time is against us.
So I thought the acceptance will not just be an acceptance, will be accompanied by something beyond that, because we're now going beyond the law and all of that. Seated here, we can't correct that. ourselves. We don't have that power. But seated here, we can reach out in the spirit of Ubuntu and say, this wisdom has opened my eyes. I'm really sorry. And in future, I'll correct it. A lot of people will find a lot of sympathy out of that. Not that we're trying to find any legal correctness or anything of that sort. It has been pointed out. The victims are watching. Commissioner Lucas made a very clear plea of what our women have been subjected to. And when they rush to justice, they don't get justice in the manner it has been presented to now. Will it cause any harm to just say, I accept I was wrong and I sincerely apologize?
Thank you, Commissioner Malema. I think I was trying to say that my approach at the time, I thought it bona fide, believed that it was the right approach. I realized, as the Commission is saying, that it was not the right approach, and I apologize for that, as I've said. Going to make sure that this particular mistake does not happen again, and I assured you that even if after this, that my cases that has to do with this type of crime, the appropriate sentence was imposed. So I'm sorry about the approach that I've used, and I'm wrong.
On that note, we have reached the end of your interview, Mr. Manyathi.
Thank you. Thank you very much, Commissioner.
You're excused.
Thanks.